Everyone. Good afternoon, good afternoon, good afternoon, good afternoon. Good afternoon. Yes, yes, yes. Yeah, greetings of the day to everyone. All right. So let's begin our class for this particular week. Our weekly ritual where we'll be discussing 3-4 important topics for this particular week. All right, so we'll begin our session today with two controversial topics that were in news. Yes, Sumit, I'm doing good. I hope the same is at your end. All right, so two controversial topics that we are going to cover today. Yes, Shefi. Yes, you will get the link for evening ethics class after some time. All right. I think that the link is not created. So evening ethics class, we'll have one session at 5 p.m. You will get the link, don't worry. Daniel says, can you give your intro, sir? All right. Okay. I hope there are, okay. There are very, very new people in the class. Chaliye, theek hai. A small introduction from my end. My name is Akash Sherawat, and so I've been teaching this current affairs from past 3 years here. All right, and apart from this, 6 successful prelims, 6 mains, 4 UPSC interviews. This is my journey in the UPSC. उसके अलावा बहुत सारे सब्जेक्ट पढ़ाता हूँ, लेकिन अभी just I'll focus only on what's this current affairs. All right. Current affairs of at least 1 year need to be prepared. If you are giving a paper in June 2022, then from June 2021 till June 2022, you should prepare your current affairs properly. However, 1.5 year current affairs give you a good edge. And if you are planning to give the paper in 23-24, then reading current affairs from now onwards is going to give you a meticulous advantage at the time when you will be appearing in your respective papers. All right. Okay, thank you. Yeah. Sir, I find it difficult to make notes of current affairs. No problem. So I know that ध्रुव गलतियां जीवन में बहुत गलतियां होती हैं, ठीक है। गलतियों के कारण इंसान हार का सामना करता है, ठीक है। चलो कोई नहीं, बहुत लंबी जर्नी है, इसमें गलतियां बताता रहूंगा, डोंट वरी, ठीक है। एक पहली गलती है कि काम को कभी मत टालो. डू नॉट सस्पेंड योर वर्क. डू नॉट लेट इट गो फॉर टुमारो कि ये तो कल कर लेंगे, आज तो रेस्ट कर लेते हैं. नेवर डू दैट. ऑलराइट, नेवर प्रोक्रेस्टिनेट. Second, make notes and keep making those notes beautiful. Not by using color pens, sketch, and no. Beautiful means keep adding information to the notes that you prepare. Do not make every time new notes. I used to do this thing. Class notes alag hain, ghar pe jaake notes alag banaunga. This is all crap. Don't do that. All right. Okay. चलिए, उसके अलावा भी बहुत गलतियां थी, फिर कभी बात करेंगे, है ना. कभी चाय पे बात होगी इस पे. अभी नहीं. All right. Now coming to one problem that almost every time a new student joins us in the current affairs class is that I find it a lot difficult to make flowcharts. Only thing, make notes out of current affairs. Only thing I would like to tell you is you have to overcome that barrier that prevent you from making the notes of current affairs. It's not a difficult task. It's just that you need to have that initiative and initiation to make those notes. All right. So like, for example, right now, if we are going to discuss the first topic, and the first topic is the Information Technology Rules 2021. Whatever flowchart that I'm going to make you draw is nothing out of my own pocket. They are what I have read from the newspaper, a couple of few things, maybe from Google, Wikipedia, or any other website that I've searched. It's just that I have mastered this art of making flowcharts. You will master it soon, but the thing is this: you have to take that first step. Do not feel disheartened in a matter of 5, 6, 7 days, 1 month. No, do not feel disheartened in a matter of 1 month. If you be persistent and make efforts for 1 month, things will be in your pocket. Don't worry about it. All right. And remember one thing that APJ Abdul Kalam, the former president of India, has said that कोशिश करने वालों की कभी हार नहीं होती. All right. So success is something else. Always strive for excellence. All right. Success will चक मार के पीछे आ ही जाएगा. All right. So Ayushi says, can you please show us your notes for reference? We are making those notes right now. They are for your reference only. Don't worry. Yogita, it's always good to, see, the thing is this, if you are making, see, it's good that you are taking this class. All right. Okay. So 4 topics will cover in this class. Almost every day, you come across various current affair videos also. But whenever you are watching a current affair video, be it me or be it any other faculty or any other person on YouTube, any other institution, remember one thing, always take a piece of paper and a paper in your hand, listen to it and make the simultaneous flowchart there itself. Once you do that, that is your own current affairs. Nobody else can take it. Nobody else can take it from you. Yes, screen is brown. Yes, Sanjana. All right. So, and club them according to the paper. Club them according to the paper. Merely making notes and throwing them away is of no good use. You have to constantly revise them also. Kindly send us the previous Saturday class PDF on the groups. Moni, I have, so those of you who haven't got the PDF of the previous lecture, both the PDFs, they are given in the description. They are given as a link in the description of the previous Saturday class on YouTube. If you search current affairs, weekly current affairs, Raj IAS on YouTube, you will get to see the list of all the lectures. जो हमारा पिछला Saturday था, that was I guess 22nd. So 22nd को जो भी हमारी class थी, all right, you can download the PDFs from the link given in the description. All right, so it may be possible that some of the groups may get skipped, but then let's just come to terms if we have some other alternative for that matter, right? Okay. So can you please share your opinion in choosing agriculture as an optional subject? First of all, I'll not talk about optional in this class, but still, because the question has already been put up, so one thing I would like to tell you. Yes, Aditya, perfect, no problem. Make notes on laptop instead of paper. It's also fantastic, no problem. Even if you are typing the notes, do not type or copy paste the same statement. Just write phrases that gives you the entire picture. All right, see, I'll not talk about option in this class, but just for one and the last time, I would tell you that if you have agriculture as your background, go for it. It's a good option. And it also opens your way for Indian Forest Service as well. Chaliye. All right, so let's go ahead now. So today, the first topic that we are going to discuss. Is the Information Technology Rules 2021, which has been Dhruv, it's once you put yourself in my shoes, you will realize how difficult it is. See, okay, overseas citizens we did in one of the previous class, Priyanka. So overseas citizens are those people who do not belong to any descent with respect to Pakistan, Bangladesh, or Afghanistan. So the people who are of Indian origin, suppose I renounce my citizenship and I apply for citizenship of some other country, then I can get an OCI card. I become the overseas citizen of India, that I am a person of Indian descent with some other citizenship. Such people are known as overseas citizens. So for example, my grandpa, he left India to United States and he got the US citizenship. My father is a US citizen and I am a US citizen. But the thing is this, because my grandpa was an Indian citizen, I have an Indian descent. So I can apply for the overseas citizen of India card, OCI card, and I will be called the overseas citizen. I am a foreign national. I have a passport of some other country other than India. I am not an Indian citizen. All right. I have a citizenship of some other country, and India do not allow dual citizenship. You remember this thing, right? India do not allow a dual citizenship. And for that matter, the overseas citizens of India are known Indian citizens of Indian descent, apart from Pakistan, Bangladesh, and Afghanistan, who want to have certain privileges in India, they can apply for OCI cards, and even their spouses are eligible. Even their spouses are eligible. All right, so that was all about overseas citizens that we did a couple of classes back. Today we are going to talk about the information tech. So it's a controversial issue that is going on, and that is the information technology. The information technology guidelines for intermediaries. Guidelines for intermediaries. Guidelines for intermediaries and digital media ethics code. And digital media. My voice is not audible. Okay. Yes. Yes. All right. Vaishali, that can certainly be done. Yes. So information technology guidelines for intermediaries and digital media ethics code. Digital media ethics code rules 2021. This is the topic that we are going to discuss. If we talk about what paper it is applicable, then this topic is applicable to, you can say, cybersecurity. Cybersecurity. You can relate it with data security as a subset of cybersecurity. All right. You can relate it with, so this is your paper 3 general studies, cybersecurity. You can relate it with governance. All right. So these rules can be asked as part of paper 2, governance. They can be used or asked in ethics paper to evaluate the ethical validity. Evaluate the ethical validity of these rules. So if they ask you as part of the cybersecurity, they can ask you what is the importance of data and why data need to be protected. All right. I'm telling you, Rahul, it is applicable to various paper. In governance, they can simply ask you the facts related to this topic. And in ethics, they can ask you to go for an analysis or ethical analysis or ethical validation of these rules. All right. नहीं पवन, जितना ज्यादा कर सकते हो उतना करो. Go for as much as you can. All right, so these are the papers with which this topic is related. Is this clear to everyone? This is your GS paper 4, GS paper 2, as well as GS paper 3. All right. Now let's look into what all things that we are going to discuss. So basically what has happened that on 26th May, the government has unleashed, or you can say the government has enforced the 2021 information technology rules. These apply to OTT platforms and these apply to the digital media, or you can say the digital social media. That's right, check. That can be done. Thank you. फिर भी question तो उठेगा. All right. So OTT platforms are known as over-the-top platforms. These are the platforms that provide you digital media on the basis of the subscription that you make to these platforms, such as Netflix, such as Amazon Prime, such as Hotstar, etc. You all know these kind of platforms that provide in India the streaming service based on subscription. All right, digital news outlets, agreed. Even the digital news outlets are there. All these platforms, they are clubbed under OTT platforms, and the government is going to regulate them. Government is going to regulate them by passing some guidelines and an ethical code as part of the IT rules 2021. Along with this, digital social medias of the category designated as significant intermediary. All right, I think it's significant intermediary. Let me look at the criteria. Yeah, it is significant social media. Yeah, you can simply call it the significant intermediary. They have to obey these rules. Significant intermediaries are any social media platform, any social media platform which has a subscription of more than 50 lakh individuals. If a platform has 50 lakh or more than 50 lakh subscriptions, right? If any social media platform has more than 50 lakh or 50 lakh subscription registered users, then that particular social media platform is referred to as a significant intermediaries, and they have to comply with these digital rules. Now, with respect to implementation of these rules, there are objections that have been raised by some OTT platforms as well as the social media intermediaries. All right, so objections have been raised. So we'll be looking into the objections and all these things in this part of this particular current affairs. So I hope that you all are getting that how we are making the flowchart of the information that we are processing. Now, when after the class, if you're making these flowcharts, you look at these papers, you will realize that there is a continuous logical flow in the flowchart and everything will put itself into place. So I think that this is the habit that you should develop. All right. Okay, Anubhav, sir, एक बार अफगानिस्तान पीस प्रोसेस देखते हैं. देखिए, अफगानिस्तान पीस प्रोसेस जब डिटेल में आएगा विल कवर, और वैसे भी उस पे एक यूट्यूब वीडियो आ चुका है. ऑलराइट, सो डोंट वरी, विल कवर इन डिटेल. हमने 1.5 घंटे के बाद पहले भी लेक्चर लिया है, एंड विल रिपीट इफ anything, any new development takes place. All right. Yeah. So objections have been raised, and all the objections and their ethical investigation will carry out. So let's discuss this. Now, this year in February, or precisely on 25th February 2021, the government of India, it framed these rules. It framed the IT rules 2021. No need to write again and again this particular thing. Guideline for intermediaries and digital media ethics code. No, you can simply write down IT rules 2021. On February 25, the government of India framed the IT rules 2021. All right, under section 87 subclause 2 of Information Technology Act 2000. No need to remember the section, just for the sake that the government of India is empowered to regulate. The government of India is empowered to regulate the OTT platforms as well as any kind of social media under the Information Technology Rules 2021. Under the IT Act 2000 and Section 87 subclause 2 empower the government of India to make such rules. These rules, they will supersede or they will replace the existing IT rules 2011. So the previous IT rules were crafted in 2011, which will be superseded, which will be replaced by these new information technology rules that are being passed in 2021. All right. Now these rules have come into effect from 26th May 2021, and the government of India is quite strict about implementation. Other services as well, Aditya. All right. So the government of India is very strict this time with respect to the social media platforms implementing these within a very short period of time from the time when they are enforced. From 26th May onwards, the social media platforms are asked to comply to these rules. So let's look at that. What are some important features of these rules? So if you look at the features of these rules, have provided a grievance redressal system for OTT platforms, all right, and digital portals of the country. OTT platforms and the digital portals of our country. So grievance redressal system means if I have some objection with respect to any material that is put up on any of the social media platform, on any of the OTT platform, then that objection is because I'm facing a grievance. So when I place an objection, yeah, they will replace 2011. That's right. So grievance, I am heard in some particular manner by these content on the OTT platforms and the digital portals, and therefore to redress my grievance, my hurt, I would be raising an objection. And my objection, which was earlier not heard directly by the platforms, will now be heard directly by the platforms by setting up of a 3-tier grievance redressal system that we are going to discuss. But one of the feature of this particular IT rules is that it has introduced a grievance redressal system for OTT platforms. All right. Now, it is necessary for the users of the social media to raise their grievance against the misuse of the social media, any kind of misuse of the digital portals, any kind of. So let's divide the provisions according to the party who they target. OTT, digital. Chahek, right now we'll be not doing it dividing them according to the parties. They are cumulatively applicable. So grievance redressal system is applicable to even the OTT platforms as well as the you can say as well as these digital platforms as well as social media. You have any kind of grievance, each OTT social media platform, every organization has to set up a grievance redressal machinery. So they are cumulative, all right? They are not individual or isolated. So Daniel, what I'm saying is, if there is a content that has been posted on any digital platform or OTT, and your feelings or sentiments are hurt, then there must be a place in that platform where you can register your complaint so that your grievance can be redressed. Like for example, recently the Tamil Nadu government has posed a question or posed an objection that the Family Man season 2 should not be revealed or should not be released on the OTT platform Prime Video, which is provided by Amazon. So they said that there is portraying of the Tamil in the bad light. So the Tamil sentiment is liable to be hurt. So right now they have approached the ministry. Right now they have approached the government. And if the government will not hear, they will approach the court, because there is no such platform available with respect to the streaming service. The streaming service is not providing the grievance redressal mechanism or not implementing it in the true spirit. And because of this reason, if people's sentiments are hurt, they have to look towards. How did a person used to approach this platform before? See, that is what I'm saying, that people used to approach the government. The government should talk to the concerned platform that such a content should not be released in on air. All right, या फिर they go for the judiciary to put a check that such a content should not be aired. All right. See, Muskan, that's the tricky thing here. All right, that should not be the case. So that becomes a criticism. So every platform, every streaming service, every digital platform, as well as social media platform, has to provide a dedicated grievance redressal system under these particular rules. Second, a significant social media firm, a significant social media firm. What is the definition of a significant social media firm? A significant social media firm is having more than 50 lakh registered users. All right. A social media firm that has more than 50 lakh registered users, they have to appoint, all right, they will have to appoint a nodal contact person and a chief compliance officer. They have to appoint a chief compliance officer as well as a nodal contact person in their respective hierarchy or bureaucracy, all right, who can be touched by the law enforcement agencies whenever a particular demand arises. The law enforcement agencies such as CBI, such as police, such as NIA, etc., in case of any investigation, if they have to contact a particular social media firm, then the social media firm has to provide them a designated person designated as the nodal contact person. All right, that nodal contact person, along with this, the social media firm has to appoint a chief compliance officer that will make sure that the new IT rules are implemented and complied with. All right. Yes, Bharti, that's correct. Yes, Gopi, that is correct. That people's sentiments, religious sentiments are every now and then heard, and it's going to create a big mess. We have to just wait and watch. Registered users, Daniel, it's registered users. So Shehnaz, what I'm saying is, under these rules, a significant social media firm means a media firm that has more than 50 lakh registered users. That media firm has to appoint a chief compliance officer that will make sure that the IT rules 2021 are completely complied with. Along with this, a nodal contact person has to be set up. All right, a nodal contact person has to be set up by the social media firm, to which the law enforcement agencies such as CBI, police, NIA, etc. can contact 24/7. 24/7, a person must be eligible or must be available from the social media firms with respect to whom the law enforcement agencies can pose requests if they need some kind of information. Along with this, it is expected that, or it is mandatory for the significant social media firm, that they also appoint a grievance officer. They also appoint a grievance officer who is going to, all right, who is going to register all the grievances, who is going to register all grievances within 24 hours. And this is the most tricky part, dispose these grievances within 15 days. Within 15 days. Yani, a significant social media firm is required to create 3 new designations. The first designation is Chief Compliance Officer, to make sure that the IT rules 2011 are complied with. Second, a nodal contact person who can be touched by the law enforcement agencies 24/7 with respect to any investigation. They also require a grievance officer who will register all the grievances within 24 hours and dispose them of within a period of 15 days. All right. Now, the next provision, the third provision that is provided is that if there are complaints against the dignity of the users, particularly women, such that the women are projected or projected as a sex object, particularly if the women private parts are exposed, or there is a usage of nudity or sexual act or impersonation, then that particular content has to be removed by the social media platform or OTT platform within a period of 24 hours after the complaint is met. See, Vishal, purpose of the nodal officer is very clear, that if the law enforcement agencies need to see who tweeted this particular tweet, what is the real identity, what is the location from where this tweet has come, they have to approach Twitter. So Twitter has to provide an officer to which the enforcement agencies can contact, that we need this and this information. Right now, the social media platforms do not provide this kind of facility to the government of India and its law enforcement agencies. So the third important feature is removal of content. Removal of content. That is, if there's a complaint which has been filed related to the dignity of users. For example, if the user is a female user and the content relates to objectification of females, if the content relates to objectification of females, nudity, pardon me. Nudity, all right, sexual, you can say sexual act, etc. Then on complaint, such content has to be removed, within 24 hours. Now suppose there is this Prime Video coming with the Family Man season 2. Then if the Tamil sentiment is hurt, then what? After a complaint is made before the Prime Video for removal of this content, the Prime Video has to remove this content within 24 hours after the complaint has been made. This is really going to curb the freedom of not just the people to express their ideas, but it is also going to curb the, you can say, the freedom of business of these OTT platforms and social media giants. So it's really something that the government is going to curb. All right. Then next, a monthly report has to be submitted about the number of complaints received and the redressal that has been provided. So monthly report has to be maintained. Monthly report, it has to be maintained. Of what? It has to be maintained of number of complaints received, as well as number of complaints redressed. All right, so this ensures accountability. This ensures accountability of the social media platforms, that includes OTT, towards the government. So the government can at any time look into the monthly report, how many complaints resolved, how many complaints received, what is the time period in which the complaint is resolved. All right, so it's a kind of, you can say, checking the freedom of, all right, this is checking the freedom of the social media platforms as well as the OTT platforms, the creative freedom, the expressive freedom that these platforms have. Because see, India is a land of big diversity. Every now and then somebody's sentiments are gonna hurt, and it is just going to create a kind of ruckus for OTT platforms to social media platforms, Ria. All right. It is going to create a ruckus for the social media platforms to operate in India. And this is the reason that the social media platforms are very wary of implementation of these rules. And many of the social media platforms, they have voiced their objections, such as Twitter, Facebook, and WhatsApp have even approached the Delhi High Court. That is also what we are going to look into. That's correct, Rakshanda. It is going to promote intolerant society. That's what we are going to write in, you can say, evaluation of these rules. See, the thing, we will come to it, Daniel. Ask me this question towards the end. All right. Yes, Kirti, they will apply to everything. All right. अभी आ रहे हैं राहुल उस पे आ रहे हैं रुको होल्ड करो है ना first creator for originator and all these things we are coming to it. Be patient. Now, along with this, these rules, they provide for 3 levels of regulation. They provide for 3 levels of regulation. The 3 levels of regulation are: number 1, self-regulation by the OTT platform itself. Self-regulation by OTT platform. Self-regulation by social media platform as well as any digital media platform. So first is self-regulation. Second is creation of a self-regulatory body, or you can say creation of an independent regulatory body. So these rules, they prescribe for creation of an independent regulatory body which will regulate the social media platforms, digital media platforms, as well as the over-the-top platforms. It will be headed by, this body is to be headed by a retired judge. A retired judge or an eminent person. Or an eminent person. And lastly, third, oversight to be maintained by. Oversight to be maintained by Information and Broadcast Ministry. Information and Broadcast Ministry. So what is happening, that 3 levels regulation will be imposed. The Kanchan, SMP stands for social media platforms and DMP stands for digital media platforms. All right. So self-regulation means that the people who are generating the content or the platform which is providing the content, they will be watchful about the content and they will resolve the problem that emerges. If the problem still persists, then a regulatory independent body will be created to look into the regulation of these OTT platforms and will be headed by a retired judge or an eminent person. All right. The definition is of Information and Broadcasting. All right. So Information and Broadcast Ministry is going to keep the check. So there is a government intervention into the freedom of media. Can you tell me, in India, the news channels, who regulate the news channels? What kind of regulation the news channels are faced? ये मत बोलना कि मोदी सरकार रेगुलेट करती है, वो सबको पता है. I am not asking de facto, I am asking de jure. By law, what body regulate the news platforms in India? Yes, Karanveer, that's right. Recently, it was in news that one of the tweets by politician was tagged as manipulated media. To what extent it stands valid? Sumit, it stands valid. It's just that that person belongs to the ruling party, that such a hue and cry has come up. The social media platforms, if they find a particular media to be manipulative, They have all the right to tag it manipulative. Are you getting my point? Think about this way. Had this particular person would have been named as, let's say, call a random name as Bambit Tatra. All right, there's any random person, Bambit Tatra, that belongs to the opposition party, और उसके टैग को अगर उसके ट्वीट को अगर मैनिपुलेटिव टैग कर दिया होता तो आज सरकार वाहवाही दे रही होती. Are you getting my point? It is just a matter of perception. If the social media platform has found a particular tweet to be manipulative and they have flagged it as manipulative, then the person who is aggrieved by this, all right, Sambit Patra, he has all the right to go and approach the court for that matter. What's the point of arm twisting or forcing the over the top, or so forcing the social media platforms? This is not democratic. This is not democratic. Are you getting my point? So do OTT platforms also have to appoint the 3 executives? Check, yes. All right. एक बार इसको मैं क्रॉस चेक कर लूंगा. हिंदू में it was not explicitly mentioned. I'll still look into what is meant by eminent person. Daniel, the problem is that eminent person is a person who is having some repute or a clout in that particular field. All right. So like, for example, if we talk about law, so today a person who has served the Supreme Court for a very long period of time, he's an eminent person of law. Like, for example, Kapil Sibal, he's an eminent person of law because he's a reputed and a well-known Supreme Court lawyer. Are you getting my point? So eminent people are like this, but the government has left this definition to itself that they will appoint some person who is known as eminent person. अब एक चीज देखिए आप, अगर eminent person की definition सरकार के ऊपर छोड़ दी तो बहुत सारी चीजें गलत हो सकती हैं. All right, I am forgetting the name of that person. He was made the director of this Indian Film Institute. All right, IFTI, if I'm not wrong. And that person do not know anything more about the cinema than performing some very small roles. Are you getting my point? So if the definition is left to the government, it provides a scope of arbitrariness. See, try to understand this way. Government has power. Government has power. And the one who has the power, it has to be checked by proper rules and regulation. If you enact rules and regulation that give that particular person who is in power a scope of arbitrariness, then that power can be misused and exploited. Are you getting my point? This is what you have to understand, that if the person who has the power, if that person is given a free hand and no check is imposed, then there is a great possibility that the power can be misused. And that is the reason that any kind of arbitrariness in these rules, any kind of restriction of freedom in these rules, it is going to be enough avenues for the one who is in power to exploit these rules to their advantage. And I need not say who is in power. So it is against democratic expression and freedom of speech. All right. What do you mean by eminent? Okay. So, okay. So news channels, they have an independent body, news broadcasting agencies there. All right. Press council. Okay. But these are independent bodies which are formed by the members from the media. There is no control over the news channels by the government. At least on paper, there is no control. The news in India is free and fair, according to, at least on paper. You all agree? So the news in India, which is coming on the television, it is self-regulatory, yes, self-regulated broadcasting. There is no government watch on these. Then why the government is imposing a watch on the OTT platforms, why the government is imposing a watch on the digital platforms, and why the government is imposing a watch upon the social media platforms? They should be led to have self-regulation. If the news channels in India, they are free to regulate themselves, then why not these agencies? We should ask these kind of questions when it comes down to evaluation of these rules. All right. Okay. Government, no, information and broadcasting do not regulate the news channels. Remember this thing. All right. NBA, that is the body that is there. There are some 42 comments. I cannot read each one of them, so I'm skipping them and we are going ahead. All right. Self-regulation है Karanveer. Press Council of India, self-regulation. चलिए, So 3 levels of regulation are there. So this is one of the things that actually bugs the most, and that is the oversight to be maintained by the Information and Broadcasting Ministry. That is the government watch. All right. So the government overwatch is going to create freedom of speech and expression being shrunk. All right. चलिए बाकी सब ये evaluation में करेंगे. Let's go ahead. So what will happen in case of non-compliance? Non-compliance will result into, number 1, ban as well as criminal prosecution. All right. It's a criminal act that you are not following these rules. So the social media platform can face criminal action as well as a ban on their services in India if these rules are not complied with. And that is also one of the reasons that it's an arm twisting. Let me look at it, Chahak. We are right now just looking collectively in these rules. We are not independently looking at different platforms. You have to give me this liberty to collectively discuss these rules right now. All right. And secondly, in examination, never ever they are going to ask you independently for OTT, independently for social media platforms, or independently for digital media platforms. They will collectively ask you to analyze these rules. All right. Okay. Then what are the concerns? What are the concerns that have emerged or have been flagged by these particular rules? So the first is that these agencies, that is OTT platforms as well as social media platforms, they have demanded 1 year compliance window. They have demanded 1 year compliance window. That is, they need at least 1 year to comply with these rules, particularly in the face of COVID-19. All right, particularly in the face of COVID-19, they need 1 year compliance window to implement these rules. But the government of India is adamant that they should be coming into force as soon as possible. All right, right from 26th May onwards. Then, secondly, because these rules, if not complied with, they have the social media platforms, they are liable for ban as well as criminal action. So this is, they have challenged these particular rules, that what is the ground for banning if non-compliance is there. Rather, there should be proper judicial litigation and not a blanket ban should be imposed outrightly. And secondly, criminal action is not justified in this case. All right, at best, it can be a civil suit or it can be a litigation before a court. Then, apart from this, so criminal action is upon the employees. So the social media platforms, the OTT platforms, they have also challenged these rules, that how come these rules can make the employee of these organizations criminal, and they have challenged these rules on these grounds. Now, another very important thing is this, that these rules, they demand information, particularly from the social media platforms, which is against their privacy policy, which is against their privacy policy. This is what we have to discuss in detail. This is what we have to discuss in detail. So the first concern is that the agencies, they say that this is the time of COVID-19, and you ask us to make a lot of change, creation of some functionaries, change in our privacy policies. All these things cannot be done in a matter of just couple of days. We need at least 1 year. All right. They need at least 1 year of compliance window to implement these rules And therefore, they say that we should be given 1 year time to implement these rules, while the government of India is adamant that they should be implemented right from 26th May onward. So this is the first concern that they have raised. Second, they have raised the question against banning or criminal action on non-compliance, and particularly the criminal action against the employees. The company is there to protect its employees, and registering a criminal case on the employees after non-compliance is actually not justified. All right, pardon me, it's a oops. All right, so it's not justified in this particular regard. The protection of the employees is the duty of the company, and this is violated. Apart from this, one more important fact is that the section 79 of the Information Technology Act 2000, it protects, all right, it protects the social media platforms from any kind of criminal litigation. Now this protection is taken away. This protection is taken away. Now the criminal prosecution will be on the social media platform and not the one who put the content on the platform. Like for example, let's take example of Padmavat. Padmavat heard the Rajput sentiments, and the litigation was put up on the director or the producer of Padmavat by the Rajputs. But this time, even let's say Prime Video, which has put Padmavat on its platform, even they are liable to be prosecuted. So this was not the case under Section 79 of the Information Technology Act. So their protection has been taken away again. All right, their protection has been taken away. I hope it makes sense now. Is it clear to everyone? And secondly, these rules, they demand information from the social media platforms, and this is against their respective privacy policies. And to comply with the government of India, they have to change their privacy policies in India, and therefore they demand the greater time for implementation of these rules. So what is this demanding of the privacy, demanding of the information? Let's discuss upon this. So what has actually happened is that under these rules, there is a liability. There is a liability on the social media platforms to provide information to the government if the government is investigating it with respect to certain acts of the individual which are of criminal nature. So under these rules, the liability is upon the social media platform, that the social media platform has to provide information to the government if there are certain acts of criminal nature committed by a person X. Right now, the privacy policies, they deny that the social media platform not to provide the information of the user to the government. But right now they are requiring, the government of India has created these rules to acquire information with respect to a particular person who has committed an act of a particular nature. Like for example, if somebody has used the social media platform that has resulted into any threat to sovereignty of India, which has resulted into threat to the integrity of India, which has posed a threat to friendly relations with the neighbors or friendly international relations, which has posed a threat to the security of the country, all right, security of the country. All right, if it is an incitement to any offense, then under such circumstances, the social media platform has to provide the government information about its users. This is against the current privacy policy of the government of the respective social media platforms. Now, this extraction of the information from the social media platforms, it is undemocratic. It is undemocratic, and it goes against the right to privacy. This goes against right to. So Dhruv, it will be the government who will decide. Who is going to decide if there is a threat to sovereignty, integrity, friendly international relations, security to the state, and incitement to offense? Who is going to decide it? The government is going to decide it. And it is not just that you will be requiring a judicial order for release of information. It is not that you will be requiring a judicial order for release of information. Even a government order is sufficient for extraction of this information. This is also one of the biggest loophole in this law, that even the government is empowered to extract information by order. Are you getting my point? It is equivalent to snooping. It is equivalent to what is the procedure for deciding. Seriously, Dhruv, do you want me to tell you the procedure for deciding? भैया, I am in power right now. मुझे अपोजिशन पार्टी के बंदे ने कुछ लिख दिया, मेरे को प्रॉब्लम है उस ट्वीट से, तो मेरे को कितना टाइम लगेगा ये डिसाइड करने में? Are you getting my point? The government decides for itself. What is the procedure? I think it's a redundant question to be answered here then. Yeah, it is. Karanveer, it is against. It is certainly against. You will have to provide me the clear picture, Akash, there. All right. Daniel, they were providing only on a government, or sorry, only on the judicial order being passed. See, the thing is this, I do agree that we should not criticize entirely these rules, because somewhere it is also going to protect your data. But we have to also look into that to some extent, the freedom of speech and expression must be there. Like, for example, I am not against the information not coming from the social media platform. I am not against the information, or any general person is not against the information to be extracted from the social media platforms. Yes, in case of sovereignty, in case of integrity, in case of friendly relations being violated, in case of security of the country being threatened, in case of incitement to offenses, in these scenario, my dear friends, yes, the person's information has to be extracted, but you need to come through a judicial route. The judiciary must demand this information, not the government of India. Government of India demanding the order is equivalent to the breach of right to privacy, which was equivalent to be a fundamental right under which case? Which case? Yes, Dhruv, that's the thing. There's a lot of scope for the government for arbitrariness. Yes, Puttaswamy. All right. So under KS Puttaswamy judgment, right to privacy has been equated to be a fundamental right. Right to privacy has been part of the fundamental right, that is right to life and dignity. All right. Then this is also against right to anonymity. This is against right to anonymity. I have all the right to be anonymous and express my information. All right. And Supreme Court has recently even upheld that right to anonymity is part of the right to privacy, which is already part of Article 21. All right. Then these demands, they demand end-to-end encryption to be terminated. Now try to understand this thing, that whenever you message somebody on WhatsApp, there is a message that is displayed that this message is end-to-end encryption protected. That means anybody in between cannot snoop in or extract information out that you are trying to communicate to somebody else. Now, because the government demand the information, demand the data, because the government demand to know the originator, then this end-to-end description will be terminated, and this will result into increased vulnerability of platforms to cyber threats. All right, it will increase the vulnerability of the platforms to cyber attacks. That's correct, Daniel. Very much correct. That's right. All right. So it demands end-to-end encryption to be terminated. That means the protection of your data is threatened, and so is the platform. So there will be constant threat of, you can say, cyber attacks upon the platform. And lastly, you can say that it is violation of fundamental right to freedom of speech and expression. All right. This is the concern that is associated with this particular law. Till this point, is it clear to everyone? See, Priyanka, that is the thing, that for the government to extract this information, अब गवर्नमेंट को ट्वीट भी चाहिए, तो ट्वीट चाहिए तो फिर end-to-end encryption has to be deleted. All right, like suppose I am one person communicating to my comrade who is another person, and the government think that we both are threat to the security. The government need what messages we exchange. So that message can only be extracted from the server if end-to-end encryption is not there. Are you getting my point? And if end-to-end encryption is not there, then what is going to happen? Then the cyber security of the platform will be compromised, and platform can be cyber attacked, and the data can be leaked into the public domain. So it is against cyber security. Second, the government capable to furnish order for extraction of information about the originator of the data. This is violation. It is arbitrary use of power by the government. All right. Third, right to privacy is threatened. Fourth, right to anonymity, which is part of right to privacy according to Supreme Court, is threatened. And lastly, right to freedom of speech and expression is threatened. Are you getting my point? So let's look at this from an ethical perspective. If you look at this from an ethical perspective, try to see, number one, individual life, liberty, and dignity, they are sacrosanct. They cannot be compromised entirely, because according to John Locke, we have certain inseparable rights, and no government can separate those rights from us. Right to health, liberty, possession, and property. All right, chalo, property is forgotten, wo Western concept hai. But right to life, liberty, and health, it's our own. We have right to freedom of speech and expression. They are inseparable rights. And now, any kind of arbitrariness, any kind of free hand to the government that result into curbing of these rights, it's uncalled for. It's uncalled for. Anonymity is like you don't want to reveal your name. All right. No. Government's view of what poses a threat to national security and security is already very obscure. That's right. In the Disha Ravi case, the Disha Ravi, which was the Greta Thunberg toolkit, all right, environmental toolkit, that farmer Andolan toolkit incident that came up, the government portrayed Disha Ravi to be anti-national, And in the first hearing itself, the court has acknowledged that the Disha Ravi was accused in the wrong charges. Are you getting my point? So the government can, that's what I'm saying, that judiciary is judiciary and government is government. The government cannot take place of the judiciary. Otherwise, the checks and balances are completely destroyed. Are you getting my point? I hope Zoom hasn't applied. All right. Okay. See, another thing that you should understand is media must be free, fair. There must be free, fair views and news. If media is to be regulated, then there should at max be self-regulation, and self-regulation only by the members of the social media, digital media, or OTT platform. Are you getting my point? For example, the news broadcasting through the channels in India, it is self-regulated. There is no extraneous regulation upon the news channels. Similar kind of treatment must be extended even to the social media platforms. देखिए बाकी ऐसा है. The thing is this, that there is no end to this debate. We have to make some peace anywhere. Before going to the next topic, I would like to tell you one thing. When it comes down to government policies, programs, and schemes, never ever go into very detail. They try to evaluate you from a very macroscopic point of view. All right. Until and unless you are a student of a law or public policy, you do not need to go and look into the components. All right. So try to assess IT rules 2021 as a complete in itself. All right. What are the provisions? What are the concerns? What are the objections? And what are the ethical evaluation? Rajwal, the problem is with respect to how this information is extracted. In other countries, there is judiciary that demand this information and that can be provided. But in case of India, it is merely the government. All right, the government has been also empowered to extract this information. That is wrong. Government is not entitled. Judiciary can seek information that's correct. Are you getting my point? That's correct. Correct, Dhruv. That's very much true. So what about iOS, in which they have social media app as iOS? Apple says they provide high level of security of data. See, the thing is this, iOS apps, the apps like Twitter, Facebook, Instagram, whatever be the app there is, that has that will come under the IT rules, no matter what Apple's agreement is with those companies. Those companies will be brought under India's IT rules, otherwise they cannot operate. We need Data Protection Act. Yes, we need. So the thing is this, that yes, to bring IT rules in India at par with the Western countries. In Western countries, there is a considerable check upon the social media platforms, but at the same time, they do not go for the government exercising that check. That check has to be exercised by the self-regulated social media. That check has to be exercised either by the judiciary. But a complete exercise of these checks by the government is not called for, because many times in these kind of conflagration, there are two belligerents. One is the government and second is the user of the social media. So it is one against the other, and one is exploiting the social media against another. That is the reason that is one of the problematic features that must be undone. That's correct, Gopi. Accepted. Now let's look at another news, and that was related to a campaign that was launched, and that was known as Save Lakshadweep. All right, Save Lakshadweep campaign that was launched. So what has actually happened, that recently land norms or land rules, they were brought in Lakshadweep by the administrator of Lakshadweep, Mr. Praful Khoda Patel. Mr. Praful Khoda Patel. So these land reforms were brought in by the administrator of Lakshadweep, Mr. Praful Khoda Patel. All right. So before going ahead, Mr. Praful Khoda Patel was an administrator or is an administrator of Dadar and Nagar Haveli, Daman and Diu, as well as now Lakshadweep. He was given the charge of administrator of Lakshadweep in December 2020. And after given the charge of administrator of Lakshadweep in December 2020, he has passed certain rules, and these rules are not popular among the people of Lakshadweep, or you can say these rules turned out to be unpopular. What are these rules? There are certain rules that he has passed. ये ललन टॉप मीडिया देख लो, आप स्कूप वूप देख लो, all these media upon the YouTube which are providing you news on their platform, they are the digital media platforms. All right. He is a politician. See. अच्छा, आप लोगों को administrator का नहीं पता. I'm sorry. I should first tell you what is an administrator. In India, you have states and you have union territories. In the states, there is a governor and there is a chief minister and his council of ministers who aid and advise the governor. In the union territories, apart from Pondicherry and Delhi, the other union territories, they have an administrator who is also known by the name such as Lieutenant Governor in case of Delhi and Puducherry. In case of Delhi and Puducherry, there is a Lieutenant Governor who is to be aided and advised by the Chief Minister and the Council of Ministers in Puducherry and Delhi, because Puducherry and Delhi are the only union territories in India that have a legislative assembly. Now, apart from Puducherry and Delhi, all other UTs have administrators that look into the administration of these union territories, and they are appointed by the president. These administrators are appointed by the president. Now, the thing is who can be an administrator? Priyanka, anyone can be an administrator. Anyone can be an administrator, but he or she has to be appointed by the president. But you cannot pick up any random Tom, Dick, and Harry to be the administrator. That people have some prominence, or you can say they are the eminent people who are appointed as the administrators. All right. And yes, pardon me, Noor. Yes, pardon me, Noor. Even Jammu and Kashmir and Ladakh, even they are union territories. All right. Pardon me for that. अब देखो, अभी बात करते हैं, है ना? Yes, we are coming to it. So this gentleman, Mr. Praful Khoda Patel, who is a politician by origin, he was made the administrator of Andaman and he was made the administrator of Lakshadweep in December 2020, and he passed certain rules which has become unpopular among the people of Lakshadweep. For example, he passed the Lakshadweep Development Authority Regulation. Lakshadweep Lakshadweep Development Authority. Lakshadweep Development Authority Regulation 2021. Next, he passed the PASA. PASA stands for Prevention of Antisocial Acts. Prevention of Antisocial Activities Acts. All right, PASA. And he also created a draft Panchayat notification draft panchayat notification. All these three rules that were passed by the current administrator of Lakshadweep are highly unpopular among the people of Lakshadweep. So let's look at Lakshadweep Development Authority and why it is unpopular. So according to the Lakshadweep Development Authority Regulation 2021, the administrator has the power to remove or relocate islanders from their property for town planning or any developmental activity. All right, for town planning and any developmental activity. For town planning and any developmental activity, administrator can remove anyone from any possession. Administrator can remove anyone from any possession or from any property possession. That is, the islanders, they can be removed from their property that they possess. All right, under the PASA, that is Prevention of Anti-Social Activities Act, any person can be detained. All right, any person can be detained without public disclosure. Without public disclosure for a period of up to 1 year. Anyone can be detained without public disclosure for a period of 1 year if he or she is thought to be involved in antisocial activities. And according to the draft panchayat notification, a member with more than 2 children, a member with more than 2 children is disqualified from the panchayat or the local government. All right, along with this, there was a beef ban as well. All right, there was a beef ban as well. चलो beef तो अब नहीं लिखना पेपर में बेटर रहेगा, ठीक है, बाकी तो बहुत ही अजीज लजीज guy. All right, just kidding. All right, so let's not write that thing in the paper, but yes, beef act is also opposed by the islanders. All right, so let's so even Kerala has objected to these act, which is a nearby state to Lakshadweep. So these three acts have been issued. All right, now the thing is this: if you look at the Lakshadweep Development Authority regulation rules that creates the Lakshadweep Development Authority, it has an extensive power and a power to even evict the landowners, which is bad. All right, now it is thought upon that Mr. Praful Khoda Patel has come out with the Lakshadweep Development Authority because of real estate lobby. जो रियल एस्टेट के साथ डील करते हैं, all right, that is जो कंस्ट्रक्शन लैंड प्रॉपर्टी के साथ जो डील करते हैं, they have actually lobbied against Mr. Praful Khoda Patel to make him pass this land development, Lakshadweep Development Authority regulation, or Lakshadweep Development Authority is being created. All right, now legislation vests extensive power with the authority, allowing it to prepare comprehensive development plans for any area and relocate people. And now there are great chances that this authority will develop nexus with the real estate lobby, such that the common people will be exploited by the real estate agents. All right, then this Prevention of Anti-Social Activities Act, it leads to detention of people for up to 1 year on pretension that they are involved in social activity. It gives arbitrariness to the government, and this can be used against the people. It can be used easily against the people. And this panchayat notification, a member with more than 2 children disqualified from the membership, this is an oppressive antenatal. It is an oppressive antenatal policy. India has never used antenatal oppressive policy, which is majorly a characteristic feature of a dictatorship regime. Like you can say authoritarian regime like China. They have gone for oppressive antenatal policy, but not in case of India. Antenatal means that try to restrict births. All right. Antenatal means that try to restrict birth. Yes, it's violating fundamental rights. That's right. Arbitrariness is there. Right to freedom, right to life is being threatened here. So koi nahi, litigations dal denge, tension na lo. All right, and it will be struck down. The problem is that if you look at the previous administrators, so the people who are against these rules, they say that it is because the quality of the administrator is very poor this time. Because the previous administrators, they used to be the civil servants. So वो कहना चाहते हैं, the previous civil servants, they were the people with some brain. All right, they were the people with some brains. But इस बार थोड़ा सा काम खराब हो गया. All right. So if we look at some of the administrators of Lakshadweep, like for example, before Mr. Khoda Patel, Praful Khoda Patel, it was Dineshwar Sharma. All right, Dineshwar Sharma. He was a prominent IPS officer who also acted as an interlocutor between between government of India and the government of Jammu and Kashmir. Then Mr. Mihir Vardhan. Mr. Mihir Vardhan was an IAS officer. All right. Before that, Mr. Farooq Khan, he was an IPS officer. Vijay Kumar was an IAS officer. So the civil servants, they were the previous administrators, but this time a politician who is supposed to have some strong nexus with the real estate lobby is made the administrator, for which he has passed certain rules which are unpopular among the common people of Lakshadweep. All right, so this was the issue that emerged with respect to Lakshadweep. I hope this makes sense to everyone now. Administrators, Sumit, it's purely administrators. Real estate are the people who deal in land plots, all right, town planning and construction of big homes and all these things. They are basically, yes, Karanveer, that's right. PASA is similar to Rowlatt Act. Okay, you can laugh at it off. That's correct. No, Dev, no. Here you are being disqualified. आपको job से थोड़ी निकाल दिया किसी ने. All right. It's not that government can pass retrospective act. If you have 2 children, you will be thrown out of the government service. That's not the case in India. Vishav, maybe because of beef ban. All right. Okay. See, governor is always in the state. So try to appreciate this thing that so governor hai, the term governor is used for the state constitutional dignitary. Lieutenant governor is used for Delhi. And if I'm not wrong, it is Andaman and Nicobar. Am I right? You use the term Lieutenant Governor for Delhi and Andaman Nicobar. Is it clear? But क्या वो apply, क्या वो implement हुई थी Karanveer? That is bigger question for Puducherry as well as Jammu and Kashmir and Ladakh. All right, and all other UTs such as Chandigarh, Dadar and Nagar, Daman and Diu, Dadar and Nagar Haveli, and Lakshadweep, they have administrator. They have administrator. There's not much of a difference between them. You can interchangeably use, but the only thing is that governor is different. Governor is in the state, LG, and administrators, they are in the UTs. Delhi uses a separate term, Lieutenant Governor, along with Andaman Nicobar, Jammu and Kashmir, and Ladakh, as well as Puducherry. चलिए ठीक है. Okay. See, for all UTs, it's not. See, basically, Lieutenant Governor and Administrator are one and the same thing, but the terminology is different for different UTs. That's it. All right. Apart from this, you need not know anything more about it. All right. चलिए ठीक है. Let's go ahead now. The next thing that we are going to discuss, it is known as sick building syndrome. It's a potential question in your mains examination. Sick building syndrome. Sick building syndrome. So basically what has happened that the principal scientific advisor to the government of India has pointed out that the reason for high incidence of COVID-19 cases in India is because of what he referred to as the sick building syndrome. According to the Office of the Principal Scientific Advisor, the sick building syndrome is the health hazard that emerges due to what? That emerges due to poor ventilation. Or you can say poor indoor ventilation of the buildings. No, I didn't get what's the special issue means. The special issue is that the people, they have agitated against. So basically there was a campaign that was Save Lakshadweep campaign. So what was the reason for the people of Lakshadweep coming together to launch this particular campaign, that is Save Lakshadweep campaign? And it gives you an example where the government policies are objected openly by the people for whom that policies are being crafted. Are you getting my point? Now this shows absence of a legislative. अब देखो यहाँ पे चलो ये लक्षद्वीप वाले पे चहक ने पूछ ही लिया कि what more can be extracted from here. तो एक चीज मैं आपको बताना चाहता हूँ. If the government is not an elected government, then the people's aspirations are not reflected. Administrator of Lakshadweep is not an elected body. He is rather a presidential appointed person. And because of this reason that he does not fear any kind of backlash in the next general elections, he has gone for crafting those policies and programs which, instead of benefiting the people, is instead harming the interest of the people. Are you getting, Chahek? So you can use this point, or you can use this question in multiple forms. First of all, they can simply ask you that what was the reason for the recent backlash of the people of Lakshadweep against the administrators' dictates. So ये तो simple आपको बताना पड़ेगा कि there were 3 or 4 rules which the people did not find popular because of the following reasons. And apart from this, you can use this as a case study that why democracy is important, why the people need to have their representative decorating the government. Otherwise, any day, any kind of arbitrary decision making can take place. And because the people do not elect their government, in that scenario, they are subjected to the dictates of the administrator, which can be authoritarian in nature as well. All right. Huh. So basically, Lakshadweep is a potential tourist place. All right. All right. So because of that reason, the real estate want to construct hotels and various other tourist attraction places and all these things. So real estate, आज की डेट में कहीं पे भी मौका मिले, they try to. Real estate has this tendency to exploit any possibility where they can benefit greatly. There's a tremendous competition going on there. There's a big role of money, muscle, as well as power. All right. So can we criticize the administrator while answering in mains? Yes, Sakshi. Yes, you can certainly. If the government, if the people for whom the law has to be made, if they are opposing the law, that simply means you can. But ऐसा नहीं कि वहां पे बहुत बस पत्थर मार दिया, ऐसा नहीं है. You can, but in a very constructive manner. All right, you can write the words like this is highly unbecoming of administrator, because with administrator people associate their ambitions, people associate their trust, and when these kind of arbitrary decisions are taken, it erodes the public trust. बोल तो ये रहे हो ना कि ये जो एडमिनिस्ट्रेटर ये बेवकूफ है, बट कैसे बोल रहे हो वो मैटर करता है. सो प्रेजेंटिंग योर आंसर इज मोर इंपॉर्टेंट in the examination than merely writing the words. कोई बात नहीं गोपी, but that is wrong, right? This is not the right way to make a smart Lakshadweep. Okay. Yes, that's right, Karanveer. Trust deficit is always there. Okay, chaliye, let's go ahead. So we are discussing the sick building syndrome. So a potential question may be asked that what is this sick building syndrome? So the thing is this, that the principal scientific advisor to the government of India, his office has given one of the reasons for high incidence of COVID-19 cases in India to what he referred to as the sick building syndrome. Sick building syndrome is a health hazard that emerges due to poor indoor ventilation in Indian buildings. The reason is, or for the reason for development of the sick building syndrome, because there is a greed of air conditioning industry and architects. There's a greed of air conditioning industry and architects. So the architects, they tune up with the air conditioning industry and they try to portray a picture that a closely packed chilling room, all right, closely packed air conditioning or air conditioned room, it is reflective of two things. Number one, comfort, and second, upward social mobility. So the people are projected that the houses which are closely packed air conditioned houses that try to provide you that 23 degrees Celsius comfort in a heat of 50 degrees Celsius outside. It is not just an example of comfort, but also upward social mobility. And in pursuit of this, the people ignore the standard building plan under the National Building Code. Under the National Building Code. And they do not incorporate good ventilation in their home. All right. And when the good ventilation is missing, it results into increased concentration. It results into increased concentration of viruses and other microorganisms which are capable of causing disease. This situation is referred to as the sick building syndrome. This problem is referred to as the sick building syndrome by the office of the scientific advisor. What is the difference between hazard and disaster? What is the difference between a hazard and a disaster? कोई बात नहीं डैनियल, अभी होल्ड करो, I'll tell you. What is the difference between hazard and disaster? Hazard is natural, disaster is natural. Okay, hazard is man-made. अच्छा, man-made disaster नहीं होता. Hazard is the havoc of nature, but it doesn't cost life. Hazard is a state of danger. Yes, that's correct. That I can accept. Chaliye. Yes, that's right, Sarvesh. Good. You must have seen that the places where there's a potential to catch fire, over there it is written fire hazard. And then they put a fire extinguisher there. That means that there is a potential of a fire to take place at this region, and this fire can further escalate into a disaster. So hazard is the potential of an incident to become a disaster. Disaster is an incident that has taken place that result into massive loss of life and property. Hazard is vulnerability to any sort of danger, whereas disaster is the danger which has materialized into a reality. Like, for example, the people living in the flood plains, they are prone to flood hazard. And when the flood takes place, results into massive damage to life and property, it is a disaster. Is it clear, everyone? Bharti third. So what has actually happened, that India witnessed an unprecedented rate of COVID-19 infection. So the reasons are being explored. What is the reason? Is it the mutant virus? But then mutant virus is one of the factors. There are many other factors. And one of the factors that has been given for high incidence of COVID-19 in India is by the principal scientific advisor to the government of India. He said that the reason for high incidence of COVID-19 in India is the sick building syndrome. Sick building syndrome is nothing but it is the health hazard that comes into place when the buildings, they have poor ventilation. जब buildings में हवा आर पार नहीं होती है, then it results into accumulation of the stale air inside the room. And this stale air results into increased concentration of the virus sufficient enough to make a person sick. If the air ventilation is taking place, if there's a cross ventilation of air in a room where there is potential COVID-19 patients, then the air reduces the concentration of the virus in the air to such a below level that the people may not get easily infected, number one. So in India, the buildings that are constructed today, no matter by any strata, they are having this sick building syndrome because there is a close nexus between the architects and the air conditioning industry. They both project to us a picture that the buildings that are having close, compact indoor space with no ventilation, good for air conditioning, as characteristic feature of two things. Number one, comfort, and second is the high social status. Are you getting my point? You look at the big buildings today that are being constructed, the flats that are being constructed with central HVAC, heating, ventilation, and air conditioning. This central air conditioning has made those buildings close, compact, such that air is circulated just within the building itself. It is also one of the reasons for increased instances of COVID-19 in India. It is not that these sick buildings just cause COVID-19. These sick buildings also cause many other diseases. For example, because of the sick building syndrome, there is high incidence of dampness in the room. Dampness, है ना, दीवारों पे गीलापन आ जाता है. Dampness results into growth of the microorganisms such as molds. These molds, they are kind of fungi. All right, they are just a kind of fungi, and they cause many respiratory disease, or they causes various diseases such as asthma, such as allergies, such as lack of concentration. All right, these molds, they secrete neurotoxins. They secrete neurotoxins, and these neurotoxins, they create mental, you can say, mental lethargy, allergy, as well as lack of concentration. All these are, along with these, in many office spaces, where there is no cross ventilation, there is high concentration of ozone. Ozone, is another health hazard in troposphere. Ozone present in troposphere, my dear friends, is a health hazard. Ozone present in stratosphere is not a health hazard. All right, now you see, black fungus mucormycosis भी reason है क्या? It is very less likely that mucormycosis can be because of this. Yes, it can be. It certainly can be. Are you getting my point? So I'll not negate that it is not the reason. It can be. In fact, many of the doctors are of the opinion that the reason for this black, white, yellow fungus, or let's call it the rainbow fungus, the reason is the people using the mask for a long period of time. When you use mask, the mask becomes moist, and moist space is where the fungi molds grow. And if the fungi be the black fungi, then yes, ingestion with a compromised immunity can result into mucormycosis. Are you getting my point? Then there is another reason for people to experience the yellow, white, and black fungus, and it is because the industrial grade oxygen being used, the industrial oxygen cylinders, improper water in the humidifiers. All right, no clean water in the humidifiers. They have microbes present in them, and when the people were intubated, when the people were given that oxygen, they experienced development of these mucormycosis kind of disease. All right, so there are certain molds such as penicillium, such as aspergillus. They grow in the rooms which do not have proper ventilation. They grow in the rooms where there is no proper sunlight. And because of this reason, a building is supposed to suffer from what is known as the sick building syndrome. The sickness is not because of the human health being compromised. The sickness is because of the building in which the people are dwelling in. Yes, zinc supplement is also one of the reasons for this black fungus. Correct. Is it clear, everyone? So the government of India has therefore decided that the sick building syndrome to be mitigated through the National Building Code. So soon in the National Building Code, the government is going to bring changes to accommodate anything that will reduce the incidence of sick building syndrome. Now, suppose I want to ask you one science question. Those of you who have attended science, it's fine. Those of you who have not attended, you will learn something. Can you tell me which gas is used to kill, or you can say fumigate, the rooms with damp wall that has fungus grown on it? Which gas do you use? Chlorine. Very good. That's right, Priyanka. Sulfur dioxide. You fumigate using sulfur dioxide. All right. You use sulfur dioxide as a disinfectant to kill the microbes that grow on the walls of a damp room. That's correct. So make it a make it a point. All right. So that was about the sick building syndrome. All right. see, the thing is this, so when you use certain dyes, when you use electronic equipments, there is a potential, because of the heating of the circuits, there is, you can say, emission of ozone. Ozone concentration is generally seen higher in the office spaces that use high electric components. All right. So PCB boards on heating. All right. The electrical equipments on heating, they produce. Yes, Chehak, it is. It is. But you use it as a fumigate also. All right. For fumigation, you use it to disinfect the room that has high concentration of fungi because of the dampness. Sulfur dioxide is otherwise a greenhouse gas. That's correct. And a potential agent that causes acid rain. But still you can use it. All right. This gas has many uses. As the carbon dioxide with the gas, but why do you drive vehicle? To make something out of it? Yes, but it is harmful. Tanisha, that is potentially a very fatal gas. Yes, it can be certainly used, but not in residential places. All right. Okay. So now let's look at the ordinance related to tribunals. All right. So one thing that we are now going to discuss is with respect to tribunals. So what has actually happened, that the government has recently come up with the Tribunal Reforms Ordinance 2021. The government has come with Tribunal Reform Ordinance 2021. And this reform, this ordinance, it has been challenged in Supreme Court this particular week. This has been challenged in Supreme Court for this particular week. So we are going to evaluate the Tribunal Reform Ordinance 2021. So what has actually happened, that the government of India, it has tried to reform the tribunal structure. It has tried to reform, or you can say restructure, the tribunal system in India. Those of you who do not know what is a tribunal, let me tell you. Tribunals are quasi-judicial bodies that adjudicate matters, of specific or specialized nature. These are not purely occupied by, the judicial, or you can say members of the judiciary. Rather, these are decorated by the people from the field on to which a tribunal is related to. Ordinance, ORDINANCE, ordinance. Daniel, wait for some time. अभी बताता हूँ. What is an ordinance? ये AU नहीं है, ordinance है, ORDINANCE, ordinance. Wait for some time. I'll tell you. Hold on. So tribunals are quasi-judicial bodies. Why they are quasi-judicial? Because they perform the function that judiciary do. That is, they adjudicate on the matters. But they are quasi because the member in the tribunal, they are not entirely from judiciary. It also has member from the specialized field for which the tribunal is created. For example, let's say there is in income tax appellate tribunal. Income tax appellate tribunal will have membership from the people who are related to, or from the people who have spent a good amount of experience in the field of income tax. So these people, this makes the income tax appellate tribunal as a quasi-judicial body and not a purely judicial body. The courts, the district court, session court, the high court, and the Supreme Court, these are purely judicial bodies. All right, but the tribunals, they are quasi-judicial body. So the government has passed an ordinance. So ordinance is an authoritative order. Ordinance is an authoritative order which has implementation similar to a law, which is passed when the parliament is not in session. अगर सरकार को कोई लॉ बनाना है और अभी पार्लियामेंट सेशन में नहीं है, तो जब तक पार्लियामेंट सेशन में आएगी तब तक उस लॉ को एक ऑथोरिटेटिव ऑर्डर से हम इंप्लीमेंट कर सकते हैं, एंड दैट authoritative order is known as law. After the parliament comes into power, then within a prescribed period of time, this ordinance must be enacted into a law. Otherwise, this ordinance will cease to exist. Article 123 provides for ordinance making power to the president in the union, and Article 213 provides for the ordinance making power to the president, to the governor in the state. I hope it is clear to all those who do not know what is tribunal and what is ordinance. Is it clear? So because in the budgetary session, in the budget session for 2021, yes, Daniel, but it is made by the parliament. Are you all right? Is it clear? The law is assent by the president, but it is passed by the parliament. Only then the president can assent it. Are you getting my point? But when the parliament is not power and we need a law immediately, in that exceptional scenario, ordinance can be passed. In that exceptional scenario, ordinance can be passed. So the government in the budget session for 2021-22, when neither of them, even then also, Tanisha, even then also. All right. So in the budget session 2021-2022, the government of India introduced the Tribunal Reforms, Rationalization and Conditions of Service Bill 2021. However, in this budget session, this bill could not be passed, and the parliament got what do we call? Dissolved थोड़ी हुई थी, क्या हुआ था? Parliament got suspended. What is the word that we use? No, Chahak. No, it is not a discretionary power. Adjourned. You know, the parliament was not in session. That's the right word. The parliament, the session of the parliament got adjourned. All right. Adjourned sine die. Dissolve नहीं होगा हर्षिन. Dissolve में तो फिर चचा वापस इलेक्शन की तैयारी कर रहे होते ना. All right. It will not be dissolved. Adjourned sine die होगा. या प्रोरोग होगा. Adjourn, prorogue. The session comes to an end. I think it is known as prorogue. Thank you, Shashank. I go with the choice prorogue. Prorogue is for an infinite period. चलिए चलिए ठीक है वो आपकी टेंशन है. अनुसार से पूछना मैं भूल गया यार. 6 साल हो गए मुझे. अब पॉलिटी थोड़ी पड़ी है. चलो, इट्स ओके. So to restructure the tribunals, the government could not pass an act in the budget session, and because of that reason, the government has tried to reform the tribunal structure in India through an ordinance, and that ordinance is Tribunal Reforms, Rationalization and Condition of Service Ordinance 2021, and this ordinance has been recently challenged in the Supreme Court. Actually, what happened that there were the government came out with the Tribunal Rules 2020, and the Supreme Court asked the government to revise these rules. Because the Supreme Court found that these rules have certain faults. So to undo these rules, the Supreme Court issued certain directions to the government of India to rationalize the tribunals in India. So the Supreme Court it objected to the Tribunal Rules 2020 and found them to be faulty and asked the government to revise them, and also issued certain guidelines or directions that the government must incorporate in drafting these rules or making these rules rationalized. Can you tell me which act or which case to rationalize what is known as what tribunals in India? Which case? No, article name. Which case? It was, yes, Tamil Nadu Bar Association, or you can say the Madras Bar Association case. Madras Bar Association case. So in the Madras Bar Association case of 2020, the Supreme Court issued certain directions to the government of India to rationalize the tribunals. All right. So the government of India has then come out with these particular this particular ordinance, and under the ordinance, it's interesting. Hold on. Just hold on, guys. Just a minute. I'm skipping some pages. Just hold on. Yeah, so I'm missing those pages that I prepared the notes on, and I think that I'll not continue with this topic now. We'll take up this topic in the next class. So ये जो tribunal से related topic है, there were some handmade notes, and I think that has been taken off by the housekeeper into the garbage or something. So I'll have to stop here itself, and we'll pick it up from here, and we'll discuss this tribunal ordinance next week, and we'll continue from here in the next week. All right. So really apologies on my side. I don't have those notes, and without those notes, I will not be able to teach you properly. फिर वो ऊपर से बताने वाली बात हो जाएगी. So I'll close the session here. All right. So we'll begin it the next time, the tribunal ordinance. Until then, be safe, be protected. See, the thing is this, that PDF. See, I am again telling you all, in the previous lecture, I was supposed to give you 2 PDF. If you haven't got the PDF, then there is a YouTube lecture. You can type weekly current affairs 22nd May, and you will get the lecture. In the description, there are 2 links of the PDF. Please download the PDF from there. All right. So I'll have to stop the session here, and we'll pick it up from here the next class. We'll discuss this pending topic. All right. Okay. In answer writing, we have to explain all cases, or just name is enough. Name is enough. Name is enough. Until then, everyone, do you want these flowcharts? If you want these flowcharts, you can download them. All right. You can download them from the link in the description of today's YouTube video after 1 hour. All right. I'll get them uploaded within this 1 hour, and you can even download them as well. All right. And those of you who are asking about how to make notes, I think that I'll make a video on how to make notes on current affairs, and also upload it on YouTube, so that everyone can make use of it. WhatsApp group पे भी भिजवा देंगे, कोई बात नहीं. Which is better, hard copy or digital notes? Whatever, Rishi, whatever comforts you. All right. I like my own handwriting, so I never make type notes. You may have comfort while reading type notes, go with that. So please ethics की भी screen. Priyanka, watch. See, that's a 210 MB file. So give me some time. I have to go to office and provide it in a pen drive, and then it will be uploaded. All right, maybe by Monday. All right. Chaliye, see you all next week at 12 p.m. Bye. Bye everyone. Next week, Himani, next week we'll discuss it in detail. All right. Okay. Yes, and all those who are attending ethics with me, see you at 5 p.m. You will get a link shortly. Bye.